Hello YouTube, I'm Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. Unfortunately, I already made this video. However, my computer decided that I was using up too much space with video and made a unilateral decision to stop my video because it was like, hey, you're saving too much on the hard drive. Even though this is my one purpose in existence, it's too much. And I'm just going to halt your video. So I lost, I don't know, 5 minutes of me talking at a camera, which for the world, not a loss, not a big loss. For me, I'm really looking to get out of here. It's a little frustrating. It's a little frustrating. All right, we got a question here from YouTube user Tiffany S, who asked us, why would an attorney wait until the very last minute to file a case in court? We received our right to sue letter from the EEOC in our state, Texas, in the past few months. Our deadline to file is a few days away. Can you give us some insight on how or why an attorney would do this? Thank you, Vince. So, yes, happy to. Now, quick background for everybody. If you receive a right to sue letter from the EEOC, not speaking to the Texas right to sue letter, but if you're receiving a right to sue letter from the federal agency, the Equal Employment Opportunity Commission, you have 90 days from the day you receive that letter to get your case filed in federal court for workplace discrimination, workplace sexual harassment, or retaliation related to one of the above. Now, that's a short statute of limitations. That's kind of ridiculously short. I think we can all agree. When you ask me why your attorney is waiting, there's one simple answer. She or he is busy, right? Let's just get this one out of the way. There's a lot of small employment practices in the country. Most employment practices in this country are small. They're 1 to 2 attorneys. That is in part because there's not enough employment attorneys. It's also in part because a small firm of talented employment attorneys can take on massive cases against defense firms and still be victorious and make lots and lots of money. So if you don't have a ton of money and you're an attorney and you want one of the best ways to turn attorney time and skill into dollars, then forming a small employment office can be very lucrative. So there's lots of small firms. Problem with lots of small firms is they don't have a lot of bodies to throw at a case. So let's say hypothetically they could get, I don't know, in a given month, small practice, probably getting them at most 5 right to sue letters in a month, right? That would be a little light in terms of our practice, but you know, we're not as small as these firms we're talking about. So you got 5 right to sue letters. Immediately you get them in the door, and you gotta go ahead and calendar 5 dates by which your statute of limitations runs out. Now, you're not necessarily going to file all 5 of those in federal court. 1 or 2 might go to arbitration. You might decide, like, listen, this doesn't work. I can't pour hundreds of attorney hours into federal litigation on this, or I can't cover expenses on this, whatever it is, so I can't file this federal action. And you've got then two cases that you're actually going to file in federal court within that 90-day statute of limitations. And that's not such a huge job, but it's a big job. And while you're working on those 2 federal complaints, you also have to take potential client calls because you got to keep bringing in new clients. And maybe you only have 2 attorneys, and maybe you don't even have a paralegal, or you have 1 paralegal or 1 receptionist, right? So you're getting, I don't know, I'm trying to think of what a small firm might do, 10 potential client calls a day. Well, if you're a solo practitioner and you're answering 10 calls a day, and every one of those people is trying to eat up somewhere between half an hour and an hour of your life, well, sounds like you're drafting at night, my friend. You're not probably going to have time to do right by your current clients just because you're already spending somewhere between 5 and 10 hours a day talking to potential clients, which is pretty significant problem because we haven't even talked about your current clients. Let's say you have 40, 50 current clients per year. Yeah, they're all going to call you every week to every other week. Some of them are going to call you 4 times a day, every day. you're going to have a conversation with that person. Like, hey, remember how I'm not your therapist? Right. Still not your therapist. You do have a therapist, and it'd be really valuable for your well-being and our case if you called that therapist. So I know I got super happy face or super happy fun time and I make you feel better, but not my job. Not what you pay me for. Not something I can sustainably do for you. You got to stop calling me 4 times a day. The ones who call you every week, you probably just grin and bear it and you call your clients back because you work for them. They're the boss, right? Okay, so already you got 20 to 40 current client calls per week. You got maybe 50 potential client calls per week. And you're burning somewhere between 10 and 15 hours a day on the phone. I mean, you're a small firm. We got a problem, fam. It's a serious problem. When are those complaints getting drafted? Oh my, and I forgot. You've got other cases you've got to do discovery on. You've got to oppose a motion for summary judgment and a motion to dismiss. And they both have deadlines and due dates and the 90-day window that you have to get this complaint filed in federal court. Otherwise, that right to sue letter expires on both of those new cases that are pending, right? And as we recently established in another video, an opposition to a summary judgment motion could easily take 50 to 100 hours of attorney time, right? Well, when's that going to happen? We've already established nighttime because you're answering calls all day. That's not great. That's terrifying. That schedule doesn't really sound workable. Oh, wait. Can't forget, though, you got to go to a couple mediations. You got mediations scheduled you got to go to. You got fact-finding conferences. You have some court appearances, some scheduling orders. You meet and confer. So you're going to a calendar call, burning 3 hours a day on 40 cases, I don't know, once or twice a week. And once or twice a month, you probably have a mediation scheduled. Maybe 3 times a month. Well, mediation can burn anything from 2 hours to 14 hours, frankly. Sometimes you got to sit in that seat and sweat it out, like you're a character in Rounders the movie. And I say none of this to make you feel bad for the small-time employment attorney. They wouldn't do it if the compensation didn't make it worth it, right? But why are they waiting till the last minute? It might be they're a small firm and they don't have the resources to throw at it, and they're working really hard to make sure they meet your deadline. I don't know. My big question for you is there a version getting worked on that you've seen, and are you going back and forth on revisions? Are you checking it for veracity? Are you making sure it's accurate? Are you having conversations about the strategy? What you're trying to do in that complaint, right? Like, if they have a working copy, a living, breathing document that's being iterated upon and improved upon, and you're just not happy that it's not filed, I mean, listen, I get it. You want it filed early, and it shouldn't be filed the day that it's due, but if it's progressing, they get hired a small employment firm. That's just the name of the game, right? Now, none of this should really be true if you're with a bigger firm, right? There's a whole bunch of bigger firms that have the ability to throw more attorneys at a case. And those bigger firms are going to generally work cases as teams. I don't know how other firms do it, but in our firm, we work a case as a team of 3, always. And then later on in the case, we might add a 4th attorney as the case gets ready for trial. So that's really beneficial because let's say one attorney has 3 motions and 3 like big opposition motions and 3 complaints to get done in a month. Well, you're going to have a case list meeting, and that attorney would say at the beginning of the month, like, hey, I have 300 hours of potential attorney labor time on motion to dismiss and summary judgment opposition motions. And I don't know if you've done the math, but 300 hours is more than full time in a month, right? If it's a month with 4 weeks, you're talking assuming an attorney works minimum 55 hours per week, I don't do math live on air, so let's just do the math here. 55 times 4 equals that, 220. So just with those 3 motions, that attorney is sunk. That attorney is already going to be working extended additional hours to get those 3 motions done. But she hasn't even addressed how those complaints are going to get done, or her calendar in terms of her court appearances, her potential arbitration appearances, her scheduling order appearances, or mediations. I don't know about you, but it sounds like that's not going to work. Sounds to me like the other members of her team, and maybe some members of other teams, are going to have to pick up that slack. So you might say, okay, listen, you have 3 depositions to do coming up, and 2 of those depositions are really simple. So we could prep someone to do those additional 2 depositions for you and get that off your plate. Your mediations, there's going to be an attorney present anyways who is a partner from our firm. So we can have a conversation with your client and say, hey, do you need the associate there in addition to both of the partners assigned to your case, right? A lot of clients, I'll be frank with you, they're going to say, no, it's fine. I don't care. I got the partners there. I feel good about that. Associate's great, but, associates are associates. So you go ahead. You go do your work. Okay. We just cleared up a couple more days. We have some case law sections on the summary judgment opposition motions that we could probably assign to someone else in the firm, because it doesn't deal necessarily with the details of the case, right? Like, the attorney assigned to the case is going to apply the facts because the attorney assigned to the case knows the facts, knows the case, lives and breathes the case every single day, profits based on how well the case does, right? But I could say, okay, Tommy Bahama, you've prepped this specific legal issue 14 times. I know because we have it in the server. You've prepped this issue many times. And Brunhilde over here has it, and she's never faced this specific legal issue before. So why don't you prep up the 15th round of your legal treatment, update it, make sure you have the most current case law, make sure it's the most compelling it can be, but get the case law in order for Brunhilde's summary judgment opposition papers, and then she'll apply the facts, and you two go through it together to make sure seamlessly the case law has been applied to the facts, and boom, we just cleared out 50 hours out of that summary judgment op for Brunhilde, right? And Brunhilde, she's got complaints to write, right? You see what I'm saying here? Like, you shift workload and move resources to make sure things are getting done. Cases are moving aggressively. Like, that's one of the things a slightly larger firm can offer you. By the same token, I'm not saying you always want a larger firm, right? This isn't some kind of commercial for slightly larger firms like ours, because, listen, slightly larger firms probably have more expensive fee structures because they have a lot more resources in play, and resources cost money, and that means they profit less when they win a case. So they need to, their fee structure is going to be a little bit more aggressive for the clients that hire them, right? So it's a little bit of a tension between, okay, do I want my attorneys to be down to the wire, getting stuff done, like you're describing here in your question, or do I want the confidence of knowing that my complaint will be filed in the first 6 weeks of my 90 days, because I can be confident that we have the resources with the firm I'm with. And the answer is not always get it filed right away, right? Like, sometimes I will sincerely say to people, hey, that firm, like, I've seen them litigate before. They don't have a lot of bodies to throw at cases, but they do have a lot of talent, and they care, and they're going to do right by you. So, like, that firm that might be charging you less because they have no overhead, it's just 2 really passionate litigators, they're a good choice. Like, I can think right off the top of my head of people in certain states where I'm like, that person's a good choice, right? And listen, do those firms sometimes get in trouble and end up calling bigger firms and saying, I got some caseload I can't manage. Will you partner with me on it? Sure. Yeah, that happens. Usually with the consent of clients, right? But there's a component of like we have to do that. Like that firm has to do that. The way things came down the pipe for them, down the work pipe, like it's just not viable, and they call in bigger firms, right? They're like, oh my god, I got a case. It was a great case, but it spun out of control, and now it's going to take 10,000 attorney hours because there's multiple plaintiffs, and we're talking about class cert, and I've never done class cert, and I don't have enough hands to even consider going for class cert, let alone handling a class action. So they call a bigger firm. That's how that works, right? They call a firm that does that for a living and has staffed up to do that, right? Now, all of this is a really long way of saying, like, I don't know why your firm is waiting, but it's possible. It's just workflow. Now, there's also really good tactical reasons why they might be doing it. There's definitely cases where we hold a filing because defense counsel's like, listen, I only have 120 grand for you right now, but I am begging my client to give you 4. I'm begging my client to give you 4. And here's the deal. My client right now is in charge of the operations in the United States. And I don't know in the command structure how long that's going to be true. So if you can just give me, like, Vince, if you can give me 3 more weeks, I think somebody with some actual sense is going to get sent over from, I don't know, Singapore to behave like an adult and get this case settled. And I have a great relationship with leadership in Singapore, but this guy heading up the American operations is a bit of an asshat. Like, also, I think he's friends with the guy who did the bad thing in your case, and he might not want to pay out big because it's going to make his buddy look bad. So, like, Vince, I know you got to file. I know you got to file in 4 weeks. Vince, I know you got to file. But if you can give me 3 weeks, I think I can get you the check. I think I can get you $400K. I don't know if you're having these conversations with your attorney, but often, if I had that kind of conversation with defense counsel, my response is, I don't know, client. Clearly, we got to get this complaint ready one way or the other. We can't be waiting to the last minute. We're not working on any complaints last minute. It'll be ready, and it'll be the best, most compelling document it can possibly be, far in advance. But how do you feel about 400? How do you feel? Because if you feel pretty good about it, filing this could upset the apple cart. Filing this creates public documents, and you may not want that as my client, but also the employer may not want that. That might be a big part of why they're trying to pay you to make you go away, right? So there's another really good reason why you might hold your filing, right? The list goes on. You might have a reporter that your firm is pretty tight with, and that reporter might say, hey, I will print your story if you give me an exclusive, but my window to print is 3 weeks from now. Like, I can guarantee you my site does X amount, like whatever, Wall Street Journal, New York Times, whatever it is, right? My blog, my work, whatever it is, right? Whatever. The New York Post, the Daily Mail, whoever you're talking to. We do this many eyeballs, 40 million eyeballs a week. And I and my editor can front page your story, but I need you to wait 3 weeks. I know you got to file in 4 weeks, but Vince, I need you to wait 3 weeks because there's like 4 genocides going on right now, and we're starting World War III, and I can't front page your article right now, and I really want to front page your article, and it's good for you, it's good for your client if I front page the article, so I just need you to wait 3 weeks. Now, you want to hold that filing because you want that filing, generally speaking, in most jurisdictions, to tie up in time, to match up in time with whenever the reporter goes live. In many jurisdictions, that gives you some additional protections against defamation claims. It's also going to have it. It's going to punch up. It's going to punch up the response you get, right? Reporters like printing stories tied to federally filed complaints. Reporters don't feel as comfortable. They'll still do it sometimes. They often don't feel as comfortable printing it on a wink and a nod and here's what happened, right? It's just a different level, right? It's a much better source for them to be like, well, this was filed in federal court, so I can just quote from it, right? Now, is that a good reason to hold a filing? I don't know. It depends what your client wants. If your client doesn't want press or wants to minimize press, is a terrible reason. But if your client understands that you're filing on a public docket in federal court, escalating from a private docket, and that, the court of public opinion does have to be controlled, that narrative can't be left out there loosey-goosey, because if you just leave it out there, the employer's going to control it, right? The employer's going to have lots of money in the war chest to throw around. So, you got to be smarter. You got to play harder to control that narrative, because you probably don't have the same war chest of, let's say, an IBM, right? IBM can probably outspend all the employment firms in the country combined, all of them, to control a narrative, right? And I'm not just picking a big company, right? I don't even know really how IBM makes money anymore, but they could still outspend all the employment attorneys combined, I suspect. You could probably combine all the defense firms and all their money with all the plaintiffs' firms and all their money in this field, and IBM could still outspend them comfortably, right? So controlling the narrative takes thought, takes planning. Got to be clever forever, right? And clever is forever. If you handle the press correctly and time things correctly and get the traction you're hoping for, and you're working with a reporter who maybe checks quotes with you, this is really what you said, right? And you get to hear the quote and be like, yeah, that's correct, that's what the client said. Or, no, you know what, I think the client might have said this instead. Let's check with the client, right? Accuracy is important, because inaccurate journalism can sink narratives, introduce doubt, harm the case, right? So if you're doing this all intelligently, cleverly, there's real value to waiting, and you might accommodate that reporter that you have a relationship with, who maybe owes you or needs you or has a reason to do right by you, because you're in this field and your cases are salacious and you're known for leveraging the press to control the narrative, so the employer can't harm your client by saying she was asking for it or some other just fucking nonsense, pardon my language, right? That's what they try to do. That's always the play. Oh, it's victim blaming 101, right? And victim blaming sounds really stupid when put in the right context. But victim blaming is unfortunately very compelling for human beings when the context is willy-nilly, uncontrolled, right? So Tiffany asks, I have no idea why your attorney is waiting, but I can think a number of good reasons and a number of worrying reasons. Listen, do I know attorneys who barely make their deadlines because they got a little coke problem? Sure do. Right? Bar Association doesn't seem to care. Is what it is. Are there attorneys who go out and take 150 cases as solo practitioners and have no ability to get that caseload done because that's way more work than one attorney could ever hope to achieve in a year? Sure. And they're going to come real close to a lot of deadlines, and they're going to blow a few. They might even blow a bunch of deadlines, right? So, I described a bunch of completely reasonable reasons in this video. There's also concerning, confusing reasons. There's attorneys who will tell you flat out, oh yeah, I'm going through a divorce. Or I had a disease. I broke my leg. I broke all my legs in a skiing accident at Chamonix. You're going to get a whole list of excuses. And that's not necessarily a deal breaker. In some, like, you got two broken legs? Well, okay. I understand how that would put us slightly behind. But I do note that neither your arms, nor your fingers, nor your brain are broken. So maybe you get tapping on those keys, right? And that's fine. If you're having these conversations, I think that's a reasonable thing to do. I think it's a reasonable thing to engage in with your attorney. If there's trust and mutual benefit and you are in a good position with your attorney and you good relationship with your counsel, have the conversation, right? Now listen, I definitely talk to people whose attorneys just ghost them and blow deadlines. And that's horrifying because you went through something terrible. Something absolutely horrific. You were attacked on the very basis of who you are or some kind of power dynamic for sexual purposes. It's horrible, right? And then some attorney has something wrong and doesn't get the work done. And it's entirely possible that your federal claims could be extinguished. You don't necessarily get a do-over because your attorney didn't file. It's not really how the federal government works. So, what are you going to do? You're going to call a different attorney and look to see if you still have viable state law claims or local law claims and see if you can go under those statutes, right? But you don't want to. You don't want to lose the federal claims. You want to bring all the claims in one action. It's generally going to be the best move in most jurisdictions for most plaintiffs. So listen, Tiffany, have a conversation. Hey, let me see a draft. Okay, you want to file close to the deadline. Why? Why do you want to file close to the deadline? Why are we getting so close? Why is this draft incomplete? What's going on? You have a reason? Okay, tell me the reason. We're talking about settlement. Great. Give me the full rundown. I want to know what they said and what your plan is and when you're going to finish this complaint. Like, whether the case settles or not, I want to see a completed draft by this date, right? And that's a really important conversation to have. That's the way to address this. And I would urge you, listen, you asking questions on the internet, that's great. You're arming yourself. It's fantastic. But you did hire an attorney. And theoretically, that attorney stands to make several massive piles of moolah if they resolve your case to your benefit, right? So it seems like the least they could do is answer your call or your email or even your text message. And if you ask them politely, what's going on? Why are we waiting? Why can't I see a draft? They owe you answers. And they owe you answers quickly, very quickly, right? We have a 24-hour guarantee. If it's during the work week and you're contacting an attorney here, you're going to get a response from the team within 24 hours. We're not going to leave your call sitting. And I get it. Small firms will struggle with that. They'll choke on that sometimes. It's hard. I get it. Gotta tell you, I think it's necessary. I get that it's hard. Breathing on the top of Mount Everest is also hard. But if you want to stay alive and get to the top of the mountain and succeed, I think you still got to do it. You can't stop breathing because it's hard, right? And so too is answering calls quickly, often difficult as an attorney. But if you want to get that case to resolution and maximize its value, hard or not, you got to do it. It's got to be done. There's no other option. You don't get to just call your client one day after months of ignoring her or his communication and say, hey, I got you a settlement. You're taking this much. What? You didn't ask me. I didn't authorize that settlement. I didn't even know you were in settlement talks. What are you talking about? Are you insane? Right? Like that. Viable questions, So Tiffany, I have no idea what's going on. I know that it's been half an hour now. I hope this was a useful response. I hope that you have really great reasons. Your attorney has really great reasons. I hope you get paid oodles of money. I will be cheering for you. If this video was helpful, like, subscribe, comment down below. It helps the channel to grow. And take care, everyone. I hope you have a lovely weekend.